Perfecto. Bienvenidos y bienvenidas a esta
Welcome.
paralelo
Welcome to
de
this
la
side event, the framework of the third COP of the Escazú Agreement. We've called Defenders in Climate Emergencies in the Inter-American Court of Human Rights. My name is Luisa Gomez, and I will be with you in this extraordinary panel held up by women. As context information, I'd like to tell you that currently the International Court of Human Rights is studying an advisory opinion presented by Colombia and Chile that is looking to clarify the scope of state obligation to respond to climate emergency in the framework of international human rights international law. And it has two areas. First, to consider the differentiated effects for people living in different regions and also based on specific population groups. Among these groups, we have asked the courts, what are the obligations of states for environment defenders in the context of climate emergency? And this will be our topic for today. As part of the process, the court opened the possibility for civil society to present written contributions. And in the framework of this procedure, several organizations and entities sent amicus curiae in the
personas defensoras en la emergencia climática, sus derechos de acceso, la garantía de un espacio cívico seguro. Y en este panel tenemos tres de estos escritos de amicus. Para quienes nos acompañen y no estén familiarizados con este término, un amicus curiae es un escrito presentado por
matter.
una persona o una entidad
This
que
can
sin
be
ser
presented either by a person or an entity that, without being part of a case or a judicial case, will provides information or arguments to the tribunal to support with decision making. In other words, the proposers asked as friends of the tribunal presenting their point. And this is precisely what we'll be discussing today. Number one, the central aspects for defenders and civic spaces sent to the court. And number two, best practices and specific cases about cases of access and guarantees for the work of defenders. This being said, I'll now introduce our panel, and I want to thank on behalf of all the organizing entities with us. We know it's very early for some countries on this Latin American side of the world. Our panel
ocho panelistas en este momento. Natalia Castro, abogada de la Corte Interamericana de Derechos Humanos. Sofía Jaramillo, abogada
we
para
have
el
five participants. Sofia Jaramillo, she is a lawyer for RFK Human Rights. There's a mayor who is part of the IACHR Secretariat. And we also have Laura Maria Carrizo. She's an environment lawyer from Fundeps, Argentina. And we also have the presence and the wonderful company of our Neighbors United for the Defense of the Environment, the Healthy Environment. This is a grassroots organization in Argentina, and they're looking forward to hear more from you, for you to tell us information about your fight. Thank you for being here. So with this, we can begin. We will start with Natalia Castro. She is a doctor in law and PhD in law from Sorbonne, Paris, master in public law and international organization. For this university, she is a lawyer and a researcher from the University of Colombia. She is a member of the Colombian Academy for International Law. She is a former
Natalia, te
worker
damos la
from
palabra.
the Colombian court. And Natalia, welcome.
Realmente esperando pues
You
escuchar
have the floor. And we look forward to listen to you what an advisory opinion is. For those that are not familiar, tell us more about this process, about this case of climate emergency in the court and why it is important.
La palabra es tuya, Natalia.
Muchísimas gracias, Luisa, y muchísimas gracias a todos los organizadores por esta invitación. Quiero, antes de comenzar, simplemente
We
decirles
know
que es
how
muy importante
well,
para
before
nosotros
I
como
start, I'd
parlamentarios
simply like to tell you that for the court, it is very important to participate in these spaces, not only because of this juncture that we have today, this participation with the advisory opinion, but because the Escazú agreement is a human rights agreement, and the court finally has a jurisprudence in this matter that has been historically present. And this is a historic time where it's worth considering this jurisprudence. Now, in regards to this process, as Luisa said, it started last year in January 9, 2023. Chile and Colombia requested the court an advisory opinion in cases of climate emergency and human rights. This request is based on the American Convention of Human Rights and the court's regulation. This tribunal is a regional tribunal, part of the Inter-American System of Human Rights, where we have the Inter-American Commission of Human Rights and the court, which is the tribunal entity that has competence related to solving cases in which the Commission states that country has infringed its obligation based on the Inter-American Convention or any other convention in regard to the respect and guarantee of human rights. In this context, this competence is simple but very important. It allows it to determine the scope of the obligation that derive from this instrument, from the American Convention or other human rights instruments. In other words, what this competence aims is that the court can tell the states what their obligations are. Because if you read the treaty, the American Convention, you will be finding several obligations drafted in very simple terms, very classic terms, which are the treaties of human rights agreements, where it says that the state must guarantee the right to life, the right to personal security, to the access to health, etc. And as just as many other instruments. So what this competence is about is that so that the court can tell us what the right to life means in this context and what the state needs to do. In this sense, what Chile and Colombia is requesting the court is that considering the global context of climate emergency, in which specific groups of the population see their rights threatened because of this emergency, but also that different ecosystems of the region can also suffer the effect of these events, so that the court states what the obligations of countries are. And among the different aspects proposed by the requesting countries through questions,
sobre exposición de las razones por las cuales los estados solicitantes consideran que es necesario que la Corte se
and
pronuncie.
presenting the reasons why the countries consider the court to pronounce. It consists in questions that are organized in different groups related to each specific area of the advisory opinion. One of the essential pillars in the request is related to the protection of environment defenders in the context of climate emergency. And this is also part of a larger domain related to rights to access that are recognized and enshrined in the Escazú Agreement, access to justice and participation. So the way in which the request is presented is so that the court can tell the states and set a roadmap to clearly determine how to protect environmental defenders, considering that we are living in a region where unfortunately defenders are threatened and their rights are not always guaranteed accordingly. So the request is to do with the role of the defenders in the context of climate emergency and the fundamental role they play. And for this reason, the court needs to specify the obligations that states have in this matter. And the demanding states will present a tool, or we'll talk about a traditional tool through which the court has interpreted inter-American instruments. And the court will need to interpret and define what an obligation or right is, not only based on its own jurisprudence and the American Convention, but also based on different international instruments that have interpreted the same rights. In this specific case, the requesting parties have mentioned the Escazú Agreement. They've told the court, when you define the protection framework, please consider the Escazú Agreement. Thus, the court will need to pronounce itself in this sense. Now, why is this way so interesting? Well, because historically, the court has had a very broad jurisprudence in relation to the protection of the rights of access based on the development of democracy and the importance of these rights to sustain the rule of law. In other words, the court considers, in accordance to the Inter-American Charter, that democracy is a fundamental part to guarantee human rights. States where democracy is guaranteed, only then citizens can enjoy their rights. And in this regard, it's decided to protect access to information, freedom of speech, access to justice, participation in public matters that are enshrined as specific rights in the Inter-American Convention in its articles, and the court has also referred. There's a very close jurisdictional line about the fundamental role that defenders play in a democratic society. So, human rights defenders play a fundamental role because they are a sample of the democratic health of the juridical system and of every state. So, democracy and the protection of human rights defenders has very concrete applications in environmental terms, and the court has had the opportunity to refer to these points in specific situations. For instance, in the case of Cloud Fernandez against Chile, the court specifically referred to the right to access to environmental information, considering that this is information related to projects, and this is of public interest. And for this reason, the state can only place legitimate limits based on reasonable, because information should be accessible to the public. Similarly, the court has announced itself about the need to guarantee freedom of speech in these contexts. This is also the case of the Barahona-Braico sentence against Chile presented last year, where the court referred to the Escazú Agreement and the importance of freedom of speech in this context. And on the other hand, the court has also referred to category of environmental environmental defenders in their cases. We have Caguas Fernandez's case against Honduras. The court indicated that defense of human rights not only refers to civil and political rights, but also to economic, social, and cultural rights. And in this context, it plays a very important role in accessing a healthy environment. From the Inter-American Convention, the court has recognized that there's a right to have a healthy environment, and those who defend this right and all rights related to the environment play the same fundamental role in democratic societies and deserve special protection based on the special vulnerability these people have. So the court has pronounced itself on these topics in some cases, but has not broadly developed the category of environment defenders, their rights, on how they are threatened, and in the extent in which states must protect them. So the request that Chile and Colombia are presenting in this case can allow the court to pronounce and to determine standards and to tell the states what their obligations are in a more systematic way in reference to these individuals, and what is the relation of these obligations in relation to the broader protection that vulnerable groups need in the framework of the climate emergency. Hence, the importance of this statement is to set a broader framework and to call the attention on how this is related in other rulings of the court to specific cases touching this case and the Inter-American Convention and other international instruments, not only inter-American, but regional or universal. How these are related and how states must guarantee a systematic and complete protection in this regard. Now, what is the process? What's the situation of the process now? As Lisa told us a moment ago, once the request is received, the court, based on its regulation, notified the organizations to the OAS member states. This is a very broad invitation of civil society to participate. This has been the most ample process the court has had so far. Initially, the deadline was 18th of August to receive these written requests, but the court realized that this is a very broad process and decided to extend it. So initially it was August 18, but finally that line was closed on December 18 last year, and the court received more than 200 documents from amicus curiae. It's the highest number in the history of the tribunal. The last consultory opinion was the right to care that took place in March in Costa Rica, and we received 100 amicus curiae document. So it's a process in which participation has surpassed all previous presentations, and the number of participants, organizations, and individuals is greater. So we have more than 600 organizations participating. So we have participation from all around the world, from OAS member states. Well, we had Barbados, but Vanuatu, that is not a member of our system. It's outside our region. And in spite of this, the Sen decided to present written observations. Academic institutions have participated from all around the world. And I'd like to highlight a very broad participation from communities that presented things directly. Indigenous communities, local peasant organizations, fishermen organizations, those affected by climate change that want to present their observations and their opinions to the tribunal. We also have the participation of an energy company that wanted to come close to the process. So considering this broad participation, the court decided to call for two hearings, very broad hearings, that take place outside the headquarters of the tribunal, outside of San Jose of Costa Rica, to understand the realities and to understand firsthand what is happening in the climate emergency context. The first hearing concluded last night. We were in Richtown, Barbados, where I am now, and we're listening to viewpoints of state, of international organizations, non-governmental organizations, and this was a very peculiar view from the Caribbean, from island states, about consequences of climate change, the ocean and coast areas. This hearing was an incredible opportunity. I encourage you to check the videos on the website of the court. A very important participation with very interesting opinions. The tribunal made special recognition at the closing. And we have another rendezvous on May 24 in Brasilia and 28, 29 in Manaus. We have 116 delegations confirmed for these 4 days of hearings. So it's a lot more people than the ones participating here, large delegations. And Tuesday, 28 of May in Manaus, we'll have a day completely devoted to listening to communities. But as we have communities, we have panels devoted to the role of environment defenders. We received many observations on this topic. It's not surprising considering the unfortunate situation in which defenders find themselves in this context. And the court has been following this process very closely from the Escazú Agreement. And among the observations we received and that were invited to the hearing, we have representatives from the public of the agreement that present their vision. So the invitation now to close my intervention is for you to, I want to invite you to follow this process. You can share with the tribunal in Manaus or Brasilia in May, or you can follow us through our channels, our social media, in this process that is bringing all citizens from the region closer together and wants to call the attention about the role of environmental defenders in our region and the impact that protecting these people has at the global level. Consider the emergency and the need to defend and protect the rights of those who defend rights. So this is the general framework of the process in the Inter-American Court. I want to thank the organizers again, and I'm open to answer any questions and to listen to any comments you have. So I'll give back the floor to our moderator. Thank you so much, Natalia. We truly appreciate your intervention. You've helped us quickly navigate through this topic. Thank you for explaining the Inter-American Framework for Defenders and also for explaining the process of the advisory opinion and the reasons why this is a historic opinion. And thank you for sharing firsthand the impressions from the tribunal judges about the participation in the Barbados hearings. So we really want to thank you for that. Thank you for sharing that context. And thank you for respecting time. Now we'll invite Teresa Felicia Mayer. She supports the special rapporteur for environment defenders under the convention, as well as the compliance committee of the same convention. Teresa has a broad experience in solving international controversies. She's a legal advisor in private practice and in the justice and other international fora. Welcome, Teresa. We're looking forward to listening your opinion. We know that from the Secretariat and from the Special Rapporteur of Defenders under the IACHR mentioned, this has been presented to the court. So thank you for sharing your view with us on why we cannot cover this crisis without guaranteeing the right to work for environment defenders. And please also share with us what are the risks and the threats that defenders face, especially in the context of the climate crisis, and how obligations to protect defenders under the Aarhus Convention, how this can help the Inter-American Court, and how can the court integrate these standards and best practices to the Inter-American system. So you have the floor, Teresa. Thank you.
Thank you very much, Luisa, and thank you generally for having me and for inviting the Aarhus Convention Secretariat to contribute to this very important discussion today. Maybe let me start by giving a brief introduction about the Aarhus Convention itself. The Aarhus Convention's full name, which also already gives away its content, is the Convention on Access to Information, Public Participation in Decision-Making, and Access to Justice in Environmental Matters. And that really reflects the three core pillars of the Convention, which are the right to access to information, the right to public participation, and the right to access to justice. The Aarhus Convention derives its name from the city where it was adopted in 1998, the city of Aarhus in Denmark, and the convention entered into force in 2001. An often misunderstood fact about the convention is that it's a global treaty, so it's open to accession by any member state, by any UN member state. And it currently has 47 parties from across the Eurasia region with different economic, social, and political backgrounds, as well as one country from Africa, Guinea-Bissau, which has very recently acceded to the convention. So given its success and its more than 20 decades in advancing these access rights covered by the convention, the Aarhus Convention has also really served as an inspiration for other instruments in other regions, including the Escazú Agreement in the Latin American and Caribbean region. And this is also why the Secretariat of the Aarhus Convention, together with the Special Rapporteur on Environmental Defenders under the Aarhus Convention, considered that it may be of assistance to the Inter-American Court to submit a joint amicus brief in the climate change advisory opinion proceedings. So before going into the protection of environmental defenders that the Aarhus Convention offers, it's probably important to explain why the protection the Aarhus Convention offers is really relevant, not just to parties to the Aarhus Convention, but also outside the territory of the parties to the Aarhus Convention, including in Latin America. So the Aarhus Convention really has a broad definition of the public. It's defined as any natural or legal person, and in accordance with national law, there are groups, associations, and organizations. And that really has to be read together with another provision of the Aarhus Convention, which is Article 3.9, which expressly provides that the rights under the convention apply to the public without discrimination based on citizenship, nationality, or domicile. And in practice, that means that in relation to all three pillars of the Aarhus Convention, as well as the obligation to prevent penalization, persecution, and harassment of environmental defenders, to which I will return later, the public outside the territory of an Aarhus party is entitled to no less favorable treatment than the public in an Aarhus party. So To give a concrete example, a member of an indigenous community in Ecuador who has been physically attacked or threatened by a private security company at the instruction of a Dutch gold mining company would be able to claim protection under the IACHR Convention for the failure of the Netherlands to prevent such harassment. And I'll return to that later when I talk about the mandate of the Special Rapporteur and the kind of complaints he's received. The idea in granting these IACHR rights without discrimination based on citizenship, nationality, or domicile is really based on the understanding of the IACHR Convention negotiators that environmental matters, whether it's pollution, biodiversity loss, climate change, don't stop at national borders, but affect members of the public in other countries too. And this is therefore also why it's particularly relevant in the context of the climate emergency, which obviously transcends national borders. Now, what protection does the IACHR Convention specifically offer to environmental defenders? The IACHR Convention, with its Article 3.8, imposes an obligation on all parties to prevent the penalization, persecution, or harassment of any member of the public exercising their rights under the convention. And with that article, the IACHR Convention was the first international instrument that imposed such a legally binding obligation to protect environmental defenders. You would now find the equivalent of our Article 3.8 under Article 9 of the Escazú Agreement, which is a much longer and more detailed provision than our Article 3.8 is. There are a few specific key points to note about this Article 3.8 obligation. One, it protects a wide range of actors. So as I mentioned, the IACHR Convention has a broad and inclusive definition of members of the public. And while the convention itself doesn't define environmental defenders, the Compliance Committee of the IACHR Convention has adopted a very broad and inclusive understanding of who is protected under Article 3.8 as essentially any member of the public who is seeking to protect their right to live in an environment adequate to their health or well-being. So this can be a lawyer, a journalist, a local community. It's really, really broad and inclusive, and it also has been adopted as such under the mandate of the Special Rapporteur. Now, in addition to this obligation being owed to a wide range of actors, it also covers the conduct of a variety of actors. So it doesn't just cover state bodies, such as law enforcement or courts, but it also specifically covers the acts of private or natural or legal persons that the state failed to prevent. So the conduct of a private company that the state failed to prevent, the conduct of a neighbor that the state failed to prevent. So it's both state and private individuals. And then finally, as I mentioned before, a very important aspect about Article 3.8 is that just like any other right under the convention, it protects environmental defenders in and outside the territory of an IACHR party, provided there is such a link to an IACHR party. So, for example, to give a very, very concrete example, under the mandate of the Special Rapporteur, the Special Rapporteur has taken up a complaint brought by a Guatemalan journalist in relation to the journalist's alleged penalization, persecution, and harassment in Guatemala by the subsidiary of a Swiss headquarter company. So the person is in Guatemala, the harassment happened in Guatemala, but it was allegedly by a subsidiary of a Swiss headquarter company, and that would fall under the mandate of the Special Rapporteur. Now, in concrete terms, how does this obligation really offer protection to environmental defenders? So one of the bodies of the IACHR Convention is its Compliance Committee, and its Compliance Committee can receive communications from the public regarding alleged compliance with any of the rights and obligations under the IACHR Convention, which includes alleged non-compliance with the Article 3.8 obligation. But the Compliance Committee is very much a legal process which adopts findings regarding alleged non-compliance, and therefore it takes time. And the parties to the IACHR Convention realized that there was increasing trend of attacks against environmental defenders. And so in October 2021, they established a rapid response mechanism in the form of a special rapporteur to receive cases of penalization, persecution, and harassment of environmental defenders. And this was the first international mechanism specifically safeguarding environmental defenders to be established within a legal binding framework, whether it's within the United Nations system or other intergovernmental structures. Then in June 2022, the Irish party selected the first special rapporteur on environmental defenders, Mr. Michel Faust. And the special rapporteur's role is essentially to take measures to protect any person experiencing or at imminent threat of experiencing penalization, persecution, or harassment for seeking to exercise their rights. And in doing so, the special rapporteur has adopted similar procedures to the special rapporteurs under the Human Rights Council special procedures. And this is obviously very relevant in the present context, both in the Latin American region and in relation to the Inter-American Court advisory proceedings on climate change. As many of you will be very much familiar with the latest Global Witness report, which found that 9 out of 10 killings of environmental defenders actually take place in the Latin American Caribbean region. Me as legal officer at the Irish Convention Secretariat, I support Michel Faust under his mandate as Special Rapporteur on Environmental Defenders. And maybe to come back to Louisa's questions about key trends and key risks that we've seen under the mandate now that it's been operating for 2 years. There are a number of key trends that we've seen because we're currently also traveling across Aarhus regions as well as outside of the Aarhus region to identify such threats. And I think they can be categorized into four or five categories. One is obviously physical violence and attacks against environmental defenders, as well as the threat of physical violence, including death threats. Such violence and threats sometimes are carried out directly by law enforcement, but often, in fact, actually come from private individuals or are anonymous. And a huge issue in that context is just the lack of accountability for such acts of violence. Which obviously creates this climate of impunity that further fosters distrust and a sense of powerlessness. So that is one key threat, key trend we've seen. We've also seen an increasing number of strategic lawsuits against public participation, so-called SLAPs, meaning lawsuits brought usually by powerful private or state actors against environmental defenders to essentially silence them. The majority of SLAPs that we've seen take the form of civil or criminal lawsuits for defamation or slander. But we've also seen more creative forms of litigation, such as allegations of financial crimes or even trespass, claims for trespass. And a big part of these SLAPs is also what comes with them, which is a lot of legal intimidation tactics, threats of future suits, and claims for disproportionate compensation of costs, all really aim to deter the environmental defender from speaking out, whether that is a journalist or a local activist. That is another trend. Then we've seen the increased criminalization of environmental defenders engaged in peaceful environmental protest and acts of civil disobedience regarding the climate emergency. And the Special Rapporteur has very recently released a position paper on this issue, which essentially sets out the international obligations of states in their response to peaceful environmental protests and acts of civil disobedience. And we're currently in the process of also developing further guidelines on this issue, on repression in response to peaceful environmental protests, which should be released by the end of the year. And another trend that basically sums up or fosters and feeds into the other trends is that there is just an increased limiting of civic space to exercise fundamental rights, whether that is through the adoption of restrictive legal frameworks or through the creation of a toxic public narrative about environmental defenders, both on traditional media and on social media, both through politicians as well as private individuals. And that really feeds into creating a climate where people don't feel safe anymore to exercise their rights, feeds into this increased criminalization, feeds into this bringing lawsuits to silence people. Those are really the key trends and threats that we've seen so far. Obviously, they evolve. And the more we get to talk to environmental defenders, the more we see different trends emerging. But those so far in the first 2 years of the mandate, those have really been key threats we've seen. Maybe to close off and to close off my intervention, and also obviously I'm looking forward to receive and answer any questions you may have. But I'd encourage you all to also maybe look at the website of both the Aarhus Convention Secretariat as well as of the Special Rapporteur, where the Special Rapporteur also publishes complaints he's received, where he's already received a response from the state, to give you a kind of idea of the complaints he's so far dealt with and the responses he's received from states, as it also gives you a better understanding of the threats and of the state response to the allegations. Thank you very much.
Muchas gracias, Teresa.
Thank you so much, Teresa. We really appreciate your intervention and your contributions in regards to the scope of the mandate of the Special Rapporteur for defenders under the IACHR Convention, and what you've talked about, extraterritoriality of the IACHR Convention to protect defenders in areas outside of territories of the states that have ratified the convention. And of course, you explained the threats and the risk that the defenders are undergoing and the sad trends in the framework of the climate crisis that we're undergoing. And we really want to thank you, because this now opens the path to give the floor to Sofia Jaramillo. She works in the Robert F. Kennedy Human Rights, where she directs and coordinates the work that the organization conducts in coordination from actors to protect defenders, advocacy, and technical assistance. So Sofia leads this work in Latin America, Africa, and Asia. She graduated from the University of Rosario in Bogota and has a master's degree in University of Columbia in New York. Sofia, we want to welcome you, and we have some questions to ask you. We would like to listen to your opinion on why environment defenders are human rights defenders and why there's such a need to protect them in the framework of the climate emergency. And also if you think that we should adopt differentiated frameworks to protect them. Thank you, Luisa. Well, first, good morning. Thank you all for joining us. And thank you for being part of this conversation, for this discussion coordinated by several organizations. It is an honor to share this panel with my brilliant colleagues. You're doing a wonderful work, and are you different? Yes, it's an honor to be here and to listen to you. Well, I'll share with you the main arguments that we used in the amicus that we presented to the Inter-American Court, and I will also answer the question Luisa asked me. Well, from RFK Human Rights, we namely used in Latin America Africa and some countries of Asia. And as part of our work, we're looking to promote standards to protect human rights, to set a jurisprudential dialogue, and to learn from best practices in our region. The amicus presented was organized by my colleague Haley, who is working in RFK, and we also work with several organizations. And we've heard Natalia talk about the great participation civil society has had. Our amicus was presented from the Human Rights Center from Pretoria, South Africa, with Amazon Watch, with the Latin American, the Caribbean Network, Red Lat, Article 19, his regional office presented another amicus, also with the Global Initiative for Social and Cultural Rights and the International Service for Human Rights. All these organizations have in common that we work in several regions and that we want to highlight these arguments from other juridical, regional, and international authorities. So this is one of our main objectives, to contribute to the analysis and the protection of groups and environmental defenders. So as we've mentioned, we believe that this advisory opinion represents a great opportunity to deepen and to broaden these instruments for protection and prevention for defenders. As Natalia well mentioned at the beginning, there is a robust jurisprudence from the Inter-American system in different areas. And now what the court will be doing is applying these standards in different areas, but specifically to defenders and groups of environmental defenders. So
Nosotros presentamos 4 argumentos principales que voy a tratar de resumir. El primero, dado que las personas defensoras del medio ambiente abordan
given that defenders tackle climate change through their work, the obligation of states in mitigation and prevention of climate change in their human rights obligation asks them to protect environment defenders. As I said, there are many standards that states should devote most of their resources available to mitigate the climate crisis. The Inter-American Human Rights Court has been very understanding, and the court has said that states must adopt measures to mitigate damage that could be produced and to eliminate consequences of the damage. So what we did also was to look from other authorities, from international authorities,
mitiguen los daños del cambio climático. Estamos hablando de instrumentos como la Convención Marco de Naciones Unidas sobre Cambio Climático.
instruments to mitigate climate change, the Paris Agreement,
También, por ejemplo,
and others. We also highlight jurisprudence, for instance, the Human Rights Committee, in the case of Daniel Lee and others against Australia, concluded that the fact that Australia did not adequately protect indigenous peoples against the effects of climate change and violated the rights of the community, of their family, their home, and to the right to enjoy their culture. So we brought arguments from other jurisdictions to provide the court with these examples. And as Natalia said, the court, this has been fundamental of the court that is so broad in its main. So it's important to take examples, best practices from the region, and also to refer to other international cases. We have several examples. We are very clear when stating that when this has not only been said by us, but by many others, that environmental defenders play a key role in adaptation to climate change. There are global studies that indicate that those who use only one tactic can mitigate up to 11% of climate change. And if they use protest, the allegations of
los estados tienen esta
the
obligación
damage
de
they're
los estados tienen
suffering.
la obligación de proteger a los defensores de derechos humanos. Entonces, digamos que
That is why it is
los
so important to
defensores
protect environmental defenders.
ayudan a esta mitigación.
And given that they
Entonces,
support this mitigation,
están obligados a
then they are
están
also,
obligados
states
a
are
cumplir con estas
obliged
obligaciones y
to
protegerlas.
fulfill their obligations and to
Los
protect
estados
them.
también tienen varias, digamos que específicamente las obligaciones que tienen respecto de los
The
defensores de
obligations that states have before defenders are to guarantee conditions and a healthy environment, adequate environment, so that defenders can exercise and carry out their work and conduct their activities freely. Been clear in the importance to guarantee this adequate environment. Declarations of human rights in 98 also refer to this. I'll talk about this obligation to guarantee this adequate environment. And as Teresa mentioned, we heard how these different types of violence, of threats, of harassment, and impunity for not sanctioning these crimes. We need to investigate crimes. If we comply with all obligations that have stated and reiterated by authorities, this will contribute to generate an adequate environment.
Que los defensores hagan su labor.
To allow defenders to do their work. And we've seen how environment defenders are the ones that face most risks. They have special risky situations, so the state, the obligation strengthened, need to protect them. And given their vulnerability, this is an opportunity for the court in its advisory opinion to articulate that states have these obligations in regards to environmental defenders. Later, we will better understand these specific risks that defenders face, especially indigenous communities, women, peasants, Afro-descendant communities, not only because of the work they do, but also because of the places where they live. And these communities face particular risks. The court has determined what are the obligations of the state to protect them. I'm trying to respect the time that I was allocated. The Inter-American system has also spoken about what a response from a state requires to address the risks and the need for an intersectional response to face different risks. to fight against oppression, racism, exclusion that these groups face historically, that are exacerbated in the context of the climate crisis. So we want to take arguments from different contexts to highlight the obligation and the important to address this intersectionality. These are more like the headlines of the arguments. Maybe later with some questions we can go deeper on these topics, but I'm sure that both Teresa and our friends of Vudas will go deeper on these matters. Thank you, Luisa. Thank you so much, Sophia. Thank you for accepting the challenge to respond these hard questions in record time. We really want to thank you. We really appreciate your contributions. Thank you for sharing the experience in writing the amicus and the importance that the Inter-American Tribunal, as part of its corpus juris, can also take the standards from other protection systems. I'm sure this will be very useful. So with this, I'll give the floor to Maria Laura Carrizo Morales. She is an environment lawyer from Argentina, from the University of Córdoba, and coordinator of the Environment Department, UNDEPS. She also works with the several organizations from civil society, and she is a lawyer, defender of communities. You have the floor, Maria Laura. But before that, we'd like to ask a couple of questions. First, we'd like to know, why is it so important for the Inter-American Court to adopt as part of its standards why to take the arguments from the Escazú Agreement, harmonize them in its jurisprudence? We would also like to hear from you. What are the challenges that defenders face in the context of the climate crisis? And also in energy transition that we are undergoing. You have the floor. Thank you very much. I'll answer your question, and I'd also like to address some other points about the written observation of the amicus that we presented together with several civil society organizations from Latin America and the Caribbean. Well, this matter that brings us together is worries us. It's the rights to access information, participation, and climate justice, and also the guarantee of a safe and adequate environment for individuals, organizations, and groups of environmental defenders. We made a respectful call to the court to ice the specific standards of the Escazú Agreement to specify the minimum content of rights to access information, access to environmental justice, and to standardize instruments to guarantee the protection of environmental defenders in the region, including a safe and adequate environment to carry out their work. As my colleagues have mentioned, communities and defenders are more exposed to the infringement of their rights because of the global climate change, but they also face different types of violence. related to the defense of the territory. These organizations play a fundamental role for the sustainment of life. This is why, to effectively protect the environment, states must start by recognizing the role of defenders in the context of the climate emergency, guarantee their rights, and promote safety environment for defense. The implementation of the Escazú Agreement by states that are part of the Convention is definitely a decisive step. The Escazú Agreement provides the necessary tools for prevention and to address socio-environmental conflicts. Access to information, as Natalia said, have the support of the human rights Inter-American and constitute an obligation for states. Rights to access allow the possibility to exercise other rights and to prevent, to strengthen policies. So we insist that ratification and implementation of the Escazú Agreement is a step that steps must take in the region in compliance with obligations. Another pillar is the double role of vulnerability that women play in environmental matters. They're not only in a risk position to face the crisis, but they're also suffer rights violation because of their status. The state must consider the specific risks that women face and adopt adequate measures.
Que efectuaba Luisa, es deber de los estados prestar especial atención al desarrollo de una transición energética, ambiental, social, cultural y económicamente justa. Actualmente, muchos de los procesos de extracción y producción de energías limpias o verdes en el contexto de la transición energética se están desarrollando con elevados
In the
niveles
context of energetic transition,
como consecuencia de la réplica de las prácticas extractivistas y de la violación sistemática de los derechos
there's a
humanos.
systematic violation of human rights at communities. In this sense, it's important to abandon public policies that promote models or practices in relation to the extraction of natural resources not only have a very strong environmental impact, but also narrate the rights of local communities. It is important to strengthen practices and mechanism.
Voy a pasar a mencionar algunos de los casos que hemos presentado en el amicus.
I will mention some cases presented in amicus. They all come from Latin America. The first one is from, again, Argentina. For several years, they've been suffering environmental consequences. Although that initially some countries have talked about the argument of hydraulic power as an energetic transition, this is not a solution because fracking is still using energy, non-renewable energy sources and follows the same patterns of negative of populations and territories. In past years, based on fracking, we've seen an increase of seismic events. We've had more than 401 earthquakes. And the local community and individuals from the community have demanded before justice seismic lights. This cause is for the Supreme Court of Justice of Argentina waiting for a solution. Another case is burners in Ecuador. This case, Sucumbíos Court in Ecuador ruled sentence for gas burning in the Amazon. saying that it's not only violating constitutional rights of inhabitants of the area, but it also, this is a practice contrary to international agreements signed by Ecuador in climate change matter. It was a measure to protect, but so far this sentence has not been executed. Maybe it's because of the lack of political will to end with these practices. Similarly, with the Cucuy and Salta in Argentina, these provinces share a basin where they find lithium. This is a basic, so rivers and streams feed larger water bodies, but this has a hydric fragility that is very specific. The national government and provinces are promoting the extraction of the strategic mineral for transition in spite of the difficulty of the hydric balance of the basin that is very fragile. There's huge risk that the basin might dry out. The Supreme Court of Justice ordered Salta as a protection measure to guarantee citizen participation and to conduct an environmental assessment study. Another case is the case of Brazil, owned by hydroelectrics, that although we know what the impact of this method, Brazil insists on the advance of these projects, calling them clean projects. A flagship project is Buena Basin with 179 hydroelectric projects. The proliferation of hundreds of hydroelectric projects in such a vulnerable area and so relevant for the preservation of biodiversity has advanced with the need of implementing a green energy. Nevertheless, there's not a real analysis of the dimensions or the impact that all these hydroelectrics have in the Amazon. They've facilitated steps to obtain licenses, and in some cases, they have the exception to present environmental licenses. Last case is the case of Buddhas here with us. Well, I will let themselves present their case. So to close my presentation, considering that the court, as we said, who preceded me, we all agree the court is before a historic opportunity to change the statistics, the sad statistics on violation of the vulneration of rights of the defenders. Those of us presented the amicus, we have respectfully requested the court to harmonize the rights of access and the guarantees for defenders enshrined in the convention based on the minimum standard based on the Escazú agreement, that they can interpret, considering that this is a live instrument that needs to be updated, and from then that we can strengthen our rights to access, face that we see this increased vulnerability presented by the crisis, by the climate crisis. As countries implement Escazú, we consider that states that have signed but not yet ratified must abstain acts to frustrate the objective and the aim of the Escazú Agreement. For energy transition to be respectful, to be fair, must respect the rights of the communities. Thank you. Thank you, Maria Laura. We really appreciate the arguments you have presented. Thank you for sharing your ideas with us for them to be considered in the advisory opinion. Thank you for what you've shared with us. Thank you for the cases and for explaining the different tensions that are presented in the Access Safe Environment in this framework of the energy transition. So this call of urgency worries us in the sense that we cannot justify the violation of rights on behalf of the energy transition, nor the infringement of the rights to access healthy environments. With this, I'd like to give the floor to the presentation of our United Neighbors in Defense of a Healthy Environment, VUDAS. We are very grateful to have them here in this panel. They've been working for more than 10 years. They've been fighting against contamination of their territory.
De la industria del bioetanol.
Because of bioethanol extraction. 21, they were awarded a prize, Cáceres, for all their process in defending the territory and their fight to access a healthy environment. With no further ado, we will listen to them so they can tell us about their work as women environmental defenders, how their fight has been in the context of the transition. We'd like to listen to the process, to the restrictions, to the constraints they faced, and how their rights of access have been violated, the rights enshrined in the Escazú Agreement. Argentina is a member state. You have the floor. Can you please introduce yourselves? Thank you. Good morning. My name is Rosa Acuña. I live in Córdoba, Argentina. I belong to the VUDAS Assembly. We are United Neighbors in Defense of a Healthy Environment. It's been 12 years of struggle against Porta Hermanos company. We are fighting for climate justice. They work with bioethanol and they're contaminating. This is harming us, and this is an illegal practice. They work 365 days a year, 24/7. We're permanently inhaling the chemicals floating in the air. This factory is located in the southern area. We are 3 kilometers from the University of Córdoba. This is located in the San Antonio neighborhood, right next to our homes. This is the only company in the world that is located in an urban area. This is their activities are flammable. The risk of explosion, and we experience constant fear. I live 50 meters away from this company. Our neighborhood was created in 1955 and Porta arrived in 1995. And in 2012, they started the production of bioethanol. And this started changing our lives. We started seeing different illnesses. Initially, we conducted health assessment, and in 2013, we started having respiratory problems, rashes on our skin.
Bueno, eso fue en el año 2013. Y en el
This
año
was 2013. And in 2016, the situation worsened.
malformaciones, abarca,
We started seeing children with malformations.
se puso muy grave. Y
This situation became more and more severe.
desde ese momento nos hicimos a la lucha, a pelear.
From that moment onwards, we decided to fight for this cause
Ellos nos están a nosotros vulnerando nuestros derechos.
because they are violating our rights, our right to access a healthy environment, and our right to have a dignified life. I'll give the floor to Mari. Good morning. My name is Maria. I've been living in this neighborhood, San Antonio, for 38 years. From day one that this company started operating, our problems started. From the beginning of their production activities, we realized that it was not something common, that the situation was dangerous, that it was serious for us. And soon we realized that our health problems started. And with time, we knew what their production was about, and we realized that it did not start in their factory, but it started with the tree felling and the clearing spaces so they could plant maize, and using many chemicals, pesticide. We saw the entrance of more than 20 trucks per day for their production. And that their production is very dangerous. It's very contaminant. It's not safe, as they say. They produce more than 600 liters of bioethanol for naphtha. And for this production, they need more than 1 million liters of water that they take from our network, from our water supply, also used for human consumption. This is every day. It's non-stop production. So this brought many health issues, and this is why in 2020 we decided to conduct genotoxicity studies in a private laboratory. We conducted studies to 20 children and adolescents, children that live very near the factory, and other children living farther away, living 600 meters distance. And the studies showed that 100% of the children of the study had genetic alterations. And in their bodies, they found highly cancerogenious alterations and components. Some years ago, the company had conducted audits. They need permanent audits. I don't know what for, because they're here illegally, but the amount of the fermenters, we found the same products, xylene and other chemicals, the same found in the urine of the children. So this was a devastating news for all of us, because these are our children, our neighbors' children, our grandchildren. It was devastating at the time, but we were able to recover, and we're back. Our fight, we're out to streets, we're facing justice, because we really need environmental justice. Thank you, Marie. Thank you, Rosa. My name is Silvia Cruz. I'm also a neighbor of the San Antonio neighborhood. I work with these brave warriors to protect our environmental rights. We chose this neighborhood with my family. It's always been a very beautiful place, a very important green lung in an urban area. We thought that we were strategically located near to the university. We thought that our children could attend this university. We thought we were living in a safe environment, but it was not true. All this green areas was destroyed. We lost our trees and our greenery, and it became an industrial area. We live very close to the distillation production, and all San Antonio is near these towers. This means that we are breathing the chemicals used for their production 24/7. This is bioethanol, of course, is an idea of business in this energy transition. They think they're providing solutions to climate change. And these are these false green activities, as we call them. They have great marketing to promote their business. What are the infringement of rights? They're infringing all our rights to life. Those who violate the right to life and affect nature, because we are part of nature. We're human beings, but we're always in harmony with our environment, with our surroundings. We need trees to breathe clean air. And these companies, and this company in particular, violating our rights. It's a very close partnership with the municipal government that gave them access to lands illegally next to our houses, and they never requested environmental impact studies. Our request for environmental justice was never carried out. We started with provincial justice, municipal justice. We went through all hallways of justice. They always told us we need to wait, that we needed to present proof. But it's proven, not only because we need live next to them, but because of the analysis that my neighbors have mentioned. However, they do not care that our children die. And this is how we reach the Supreme Court of our country. Because we love our land. And they're just writing about environmental justice. You'll see them in all possible congresses and hearings, but they never said something about closing the company. And they applied a procedural code 280. I know I've learned that number by heart, but we're just asking, why is this not providing environmental justice? And I can guarantee we went through all the state structure. We have our escazú on our t-shirts, our fight, our flag. This is escazú because we really believe that we are making effort from professionals, the work of professionals, educated people that are supporting us in the defense of life together with the assembly and the grassroots organizations. We are hopeful that something will work, but nothing is changing because there are companies like Porta allied to a Swedish multinational, and these companies disguise themselves in green, and they're negotiating with state and then negotiate with justice because for some reason, just judges were never able to provide us with this environmental justice so that Lucho would not die, that our neighbors do not die of cancer. For some reason, the state is too close to the companies. If we need more resources, yes, we do. Do we need an energy transition? We do, but this does not need to go against the rights to safe environment and a healthy life. We do not have an environmental justice to this day, and we really hope and we truly believe and will continue fighting. It's not easy to continue living here, but we're here. We're here to resist. We know that we can die, but we resist. We believe that Escazú can be an alternative, a force, a struggle, a joint force, a joint fight to save lives, because saving the planet means saving lives and the territories. Thank you.
Rosa, Mari, Silvia, ¿uno qué dice después de eso?
Rosa, Marie, Silvia, what can we say after this? It's so hard. Thank you so much for your brave intervention. So clear, so moving. We deeply thank you. Thank you for sharing this with us. All our admiration to you for your consistent fight, for your courageous struggle many years. We hope that this is not a process that is only left written on paper, but as you say, hopefully this is a process that can translate it in justice for you. And I think that with this advisory opinion, there's an important opportunity about rights that the Inter-American Court can provide to states on how to make justice material for defenders, for environmental defenders in the context of climate crisis, but in the phenomenon of energetic transition as well. Because indeed, we need a fair energy transition that is aligned with the minimum standards of human rights. Well, we have 3 more minutes before the end, but I would like to address one of the questions asked our chat. This is a question for Natalia, and it says, you say that there are companies, energy companies that have sent their arguments to the court. What are those arguments in general terms? This is a question for you, Natalia. We understand if there are any constraints with the information you can share. We perfectly understand.
No tienes micrófono.
Sí, qué pena. ¿Me puedes hacer una pequeña introducción de la pregunta otra vez, por favor?
Can you please repeat the question? Sure. You mentioned that there are energy companies that have sent their arguments to the court. What are those arguments in general terms?
Bueno, esto se los puedo contar así como de primera mano porque esta intervención la escuchamos ayer en la audiencia.
Well, I can
Me pareció muy valiosa, como les
talk about this firsthand because we heard about it yesterday.
estamos de acuerdo en que
And I said we
una transición energética.
agree that we need an energy transition,
Mire, independientemente de
and the request to the tribunal was
avanzados en esta materia,
regardless of
lo que
the
la Corte es que fije un marco de estándares claro
right,
para
what
que
they were asking the court is to have clear standards so that companies can have stability and certainty on what their obligations are.
diferentes visiones respecto de cómo se puede hacer la transición, pero insistían en que finalmente ellos
They insisted
participantes son una empresa que garantiza el suministro de energía, como la energía además es un elemento fundamental para poder
they
garantizar
saw
el acceso
energy as a
muchos
fundamental
y en ese sentido, como
element to access many human rights, and how the company operates. How fundamental this is to continue guaranteeing rights. So this is more or less the argument. This intervention can be found in the videos on social media of the court. This was the intervention from yesterday during the first panel of the afternoon. You'll find it there. I take this opportunity to tell you that all observations are presented on the website of the court. If you want to check those out,
tipo, ahí pueden encontrar toda la información.
you'll find this information there.
Que se expresó ahí.
Muchas gracias, Natalia.
Thank you,
Sé que
Natalia.
tenemos otras tres preguntas.
We have more
Natalia
questions,
estaría dichosa pues de hacérselas, pero ya estamos sobre la hora.
but
Son las 9:30.
unfortunately, we ran out of time.
Nuestro compromiso con la Secretaría del Acuerdo
And our commitment with the Secretariat is to finish the agreement,
Entonces, con mucho gusto,
to finish the meeting on time.
envío
So we'll
estas
be
preguntas a
glad
ustedes por
to
escrito.
send these
Ya
questions to
habíamos
you
comentado
in
que
a written
tienen
form.
de recibir la respuesta por escrito. Tenemos preguntas para las Budas.
We
tenemos
have
también
questions
preguntas para
for
las
Buddhas. We
que
have
tienen
an
que ver
open
también con
question,
Teresa.
and we have another
Las
question
vamos
for
a
Teresa.
dejar aquí
So
registradas
we'll leave
para
them, we'll
podérselas,
take note so we
transmitir a
can
ustedes.
send them to
Me
you
resta
later.
agradecer
And I'd just
infinitamente
like
la
to
presencia
thank
de,
you
pues,
all
estas
so much.
maravillosas
Thank you for the presence of
líderes mujeres
these
que
wonderful,
están
extraordinary
todas
women leaders in this panel, all of you from your different
desde sus universos
contexts and
contribuyendo
universe,
pues a
contributing
tener un mundo mucho más alineado
to make this
con
a
derechos
better
humanos,
world,
más
aligned with
seguro,
human
mucho
rights, a
más
safer
justo para
world,
los
a
defensores
more
y las
adequate
defensoras.
environment
De
for
nuevo,
defenders.
muchas gracias.
Again, thank you
Infinita apreciación por haber estado acá
so
de
much.
parte de todas las organizaciones
We
convocantes
appreciate your
del
presence.
evento y también muchas gracias a
And
quienes han
also
permitido
thank you
este
to
espacio.
all
Así
those
que
who
nos
made this
despedimos y
possible.
quedamos pendientes
Thank
de
you,
recibir
and
las preguntas.
we'll send the remaining questions. Goodbye.